Dailey. I'm a senior associate attorney here at Estelle and Kennedy. And basically this slide is just to give you a little bit of background of our history. Today we're going to be discussing family law, but we also practice in numerous other areas of law. I think family law and probate are probably the two main areas that we practice, but we've been doing a lot of civil as well as criminal law too. And then we have 3 offices. We have an office located in Upland, downtown Los Angeles, and then one in Mission Viejo as well. So like I said, today we're going to be talking about family law. These are the main areas of family law, and they're kind of the order I'm going to be discussing them in. So some people might be here just for dissolution without children. Some people might be here just for child support, child custody, and you don't need a divorce. But I'm going to go through all these areas. Dissolution is, most people call it divorce, but it's the same thing. The legal term is dissolution of marriage. In the state of California, to obtain a dissolution, you have to have lived in the state for 6 months, and you have to live in the county where you're filing for at least 3 months. It's just to establish residency, so the court has jurisdiction over you. The other party doesn't have to live here, as long as whoever files does, that establishes jurisdiction. And that's Family Law Code 2320. We're also going to talk about the difference between legal separation and data separation. A lot of people assume that, when they call in or when I'm talking to someone who might be a potential client, I ask them what their data separation is, because from that date on, the court determines how to distribute assets and debts. A lot of people assume that you have to have a legal separation to do that. That's not true. A legal separation is an actual legal document that you have filed showing that you have obtained a separation from your spouse. You don't need to have a legal separation to establish a date of separation. Data separation simply means the date that you two communicated to each other, your relationship is over, and that you're not going to be able to rekindle that or anything like that. It's going to be over. Even if you still live together, sometimes people end their relationship and they continue to live together. It doesn't matter, that's still your date of separation. And regarding legal separation, the only thing I really have to say on that is it's kind of moot to get a legal separation if you plan on obtaining a dissolution at some point. It's just going to cost you extra money and extra time. The only time I really advise clients to get a legal separation is if there's a religious, if their religion kind of forbids it, which our religions do, but most people still do that. However, some people don't want to, so that's really the time when you would get a legal separation. Other than that, I can't think of a lot of instances where you would prefer that over an actual dissolution. I don't know, I hit that, sorry. So that brings us to the next topic, is the distribution of assets and debts. So like I said, the date of separation, the date you end your relationship, that's when everything that you accumulate from that date on is going to be your separate property. So the state of California is a community property state, which means that from the date of marriage, everything that you incur, whether it's an asset or a debt, it's going to be, you're each going to have 50% interest. The husband and the wife have a 50% interest in that asset or in that debt. Unless you've opted out of the state of California's community property law, which means that you have some kind of premarital, also known as prenuptial agreement. That's really the only way to get out of it. And community property includes everything from wages to retirement, any other real property that you're given, unless it's gifted specifically to one of you separately. And then if that's the case, it remains your separate property. So separate property is basically anything that you obtained prior to marriage or post the date of separation. If you're married though and you have inheritance or any other kind of gift, like I said, that's going to remain your separate property. And just to give you an example, say today I buy a home and tomorrow I get married. That home is my separate property, and even after I get married, it remains my separate property. So whoever the husband is has no interest at all in that home. The only way that they will have an interest is for 2 reasons. One is transmutation, and the other is they contribute to it so they can get reimbursed. So transmutation basically means that I took the title that's in my sole name and I changed it to be in my name and my husband's name. Then he would have an interest in my property because he's now on a title. That's called transmutation. And you can transmute community property back to separate as well. But whoever the person being detrimented is, they have to sign off on that. So transmutation will never automatically occur. The 2 of you have to agree. It has to be in writing. And whoever is being negatively affected, they have to sign it. So a lot of people think when you get married, you lose some of your assets. That's not necessarily true. And it's not automatically going to happen either. You have to actively make it happen. So in that same scenario, say the home that I bought today and I get married tomorrow, say I want to sell that home in 5 years. I'm still married. guess what? The money from that remains my separate property money. All I have to do is make sure I keep it separated. And the smart thing to do is put it into your own account. However, you don't have to do that if you don't want to. You can keep it in a commingled account, but you have to be able to trace that money. So as long as you have $5,000 and you can trace it back, then it's still your separate property money. But you would probably want to have a separate account just to ensure that that money remains your own money. That's only if you want it to remain your own. Of course, if you want to share it, if you want to contribute it back to the community, you can do that as well, but you don't have to. And then when it comes to the reimbursement, so I'm going to stay with the same example. Say the home that I own, say I decide in 5 years to remodel it instead of sell it. If my husband contributes to that, he can, at the time we get a divorce, he can ask to be reimbursed for whatever he contributed if it increases the value of our home. So say he puts in $3,000 to the remodel, he can get that $3,000 back. He still does not have an interest in my actual home. He's still not on the title. The home will not go to him in any portion, even if I sell it. He'll just get the money back that he contributed. That's it. Now we're going to talk about spousal support. So when the couple decides that they want a divorce, they can go ahead and petition the court for spousal support. So when it comes to temporary spousal support, that's basically anything pre-judgment, which means I file today, but before the judge decides, because if any of you have been to court, you know that that can take a while before a decision has been made. If I file today, the court hearing probably won't even be for another 2 months, and then at that point, it might not be a determination. They might still need more time to decide. So until there's a final judgment, it's called temporary spousal support. And this is simply based on California guidelines, which are mostly, do I have a need for the money? Do they have an ability to pay the money? That's really all it comes down to. However, once there's a judgment, the court will decide if there's going to be permanent spousal support. And that's based on California Code 4320. There are multiple factors in that. The need and ability are still there. The court's also going to look at, if one party stopped working for a while to stay at home with the children, what the skills of that party are. Whoever's asking for spousal support sort of has to have a need for it above and beyond how much money they make now. It has to be how much money are they going to make in the future. Do they have the skills? Do they have employment lined up that they can access? Things like that are going to really matter. So if you've been out of work for 10 years, it's going to affect you more than if you've been out for 2 years. And also permanent sounds very scary to people who owe spousal support, but it's not necessarily permanent. It just means that the court's never going to terminate their jurisdiction, which means they can always award it. It doesn't mean that there's always going to be a reason to award it. So just because today the judge might order, okay, you owe $500 a month, which everyone might know that's not actually that much in spousal support. But if you owe that in 2 years, it might be reduced down to zero. It's never ever going to be terminated. The court can always order it, but they might not. They can reduce it down to zero, reduce it down to $250 instead of $500, that kind of thing. So it's all going to be based upon the need and ability to pay, as well as sort of the standard of living that the couple had during marriage. Those are the main issues when it comes to spousal support. Post-judgment means that, so say you ended, you're at the end of your case, the judge orders permanent spousal support, you move on. However, if at some point we need to have a post-judgment, you can still do that. The court still has jurisdiction to do that, and that's just based on a change of circumstances. So either party can petition the court to modify spousal support if they have a change in circumstances. For example, if I'm ordered to pay my ex-spouse $500 a month, say I lose my job, then I can say, you know what, Your Honor, my circumstances changed, I need you to reduce the spousal support, and that's going to be taken into account. On the other hand, if the husband that I'm paying $500 a month to, if he loses his job, he can ask for more spousal support. So it can always be increased or decreased. It's just based upon what's going on with the parties at that point in time. So as long as the court has remained or has retained jurisdiction, they can make those orders. Okay, now, so that's everything about really the dissolution, kind of what goes along with that. Now we're going to talk about child custody, visitation, child support. We'll get to next also. So with child custody and visitation, really the best interest of the child is the main standard that every judge has to use. And that's based upon California Family Code Section 3011, which is right here. In making a determination of the best interest of the child, the court considers a few different factors mainly. They obviously consider any factor that's pertinent that you want to make the judge aware of, but the main ones are these right here. The health and safety of the child, any history of abuse by one parent, the nature and amount of contact with the parents. So again, if we go back to that example where there's a stay-at-home parent, they obviously have much more contact with their children because they're there with them all day, possibly all night, if the child's not in school yet. And then if there's some sort of, controlled substance abuse or anything like that, those things are very, very pertinent in taking into account who the child should live with and how often there should be visitation with the other parties as well. So when it comes to child custody, there's physical and there's legal custody. Legal custody is basically who makes decisions for that child. When it comes to school, when it comes to medical decisions, those kinds of things, parents can really disagree on how they want to raise their child. Sometimes if you get divorced and only one of you has legal custody, only one of you gets to decide those issues for your child. Usually though, joint is much more common to be awarded. And in that case, you both get to make the decisions, which obviously can be very difficult because if the two of you disagree and you're divorced, it's really hard to come together and make a real decision. But judges still like to award joint because they think that both parents should be involved with their children's future and their decision-making skills. So joint is more common than sole, but sole can be awarded, especially if really only one parent is involved, because they don't want you to have to, if I'm the parent who's more involved and the father's really not in the picture at all, they don't want me to have to go search him out and find him to make these decisions. They want me to be able to do that, whenever I need to, basically. Sorry, I'm using myself as an example because I think that's just easier. This is custody, this is different. This is not decision making, this is who does a child live with and how often does a child visit the other parent. Those are the code sections that it's based on. If you all want to look up the code, you can. Basically, sole physical custody means that I have the child 100% of the time. Joint legal, which again is much more common, means that one parent is the primary caretaker, the child basically lives with that parent, the other parent gets visitation. So with visitation, really these are kind of what matter. Or these are what the courts go off of to decide how to order visitation. And visitation is almost always ordered. A lot of parents will file for sole legal and sole physical custody. Usually that's unreasonable. Usually both parents are involved and the court's going to allow both parents to remain involved in their children's lives. So unless you have a really good reason to alienate the other parent from the child, the court's not going to allow that. They're going to order both of you be able to see your child and be involved in your child's life. We're going to go talk about best interest of the child a little bit more. Like I was saying, that's the crucial determination. What's best for the child, that's how they're going to order joint custody, sole custody, physical custody, legal custody, all the things we just talked about, they're all going to be based on what's best for the child. Not what's best for the parent, anything like that. The parent kind of has to prove why they think they should be the parent raising the child or making those decisions for the child. Courts also want to take into account if one parent is going to, like I said earlier, alienate the other parent. If that's the case, they're less likely to order, primary custody to that parent. It's not impossible, it's just less likely because they want to make sure that, like I said, both parents are involved. So it's called frequent and continuing contact with the child. They want to make sure that both parents can see the child, be involved with the child. It's very important to not alienate either parent and to not interfere with the rights of parents. This is something that comes up a lot. A lot of parents think that, what if the child says they want to live with just me and not see their other parent? Judges don't necessarily go off of that too much. Sometimes it is a factor, of course. In the state of California, mostly it's once a child turns 14, the judge will consider how the child feels, who they want to live with, and why they want to live with that parent. So it's not going to be the determination if if the son goes in and says, oh, I want to live with my mom, the judge doesn't say, okay, you live with your mom. That's only one factor amongst many factors of why the judge would order one parent to have primary custody. So it also matters, like I said, if the child, why the child wants to live with that parent. For example, say the mom makes the kid do dishes and the dad lets the kid play, video games or whatnot. The judge is not going to feel like that's a sufficient reason to let the child live with the dad over the mom. It has to be good reasons why the child wants to. And even if the child's 14, the judge is going to see the judge gauges how the child is. Is this child mature enough to help make this decision? And things like that. The age and the capacity are the main items that the judge is going to take into account. And that brings us to child support. In the state of California, and really any state, they want both parents to contribute to their child. Both parents have a duty to contribute to their child, financially, physically, emotionally, but only financially can only be ordered by a court. in California, we have uniform guidelines for child support. So all of these guidelines that I'm referring to, they make the process of getting dissolution, the process of child custody visitation, support orders, they make it much more simple. People can be in huge disagreements, but really the California law helps out because when there's a uniform guideline, it doesn't really matter what you say or why. It just matters we put in numbers, this gives us an output number, and we go with that. So unless the parents want to agree to something else, it's based upon how much each parent makes, so their income, and then it's also based upon timeshare with the child. So if you see your child every other weekend, you probably have a 10 or 15% timeshare versus the other parent having an 85% timeshare. So basically that's what goes in. You input the numbers, the timeshare, the income of both, it outputs a number. That's what child support is. That's what it's based on, nothing else. Again though, this is something that can be modified. And it can be added on to as well. So add-ons, the typical ones that I've seen are if there's childcare costs. So if you have your child in some sort of daycare or other program like that, that costs you extra money per month. Both parents usually have to pay half of that. And then if there's something that goes over for insurance, if you have an insurance fee that's a reasonable fee, that you've got, something reasonably, and it goes over, then both parents have to pay for whatever went over. Here's the modification that I was referring to. Again, just like with spousal support, for child support to be modified, there has to be a material change in circumstances. Same kind of thing. If your income increases or decreases, the other party or you can file to get child support. And with child support, a lot of times, to even get it ordered, you can go through Department of Child and Family Services. They can help you get an order for child support, and they can also help you enforce the order. Attorneys can do the same things, of course. The way we do it is just a little bit differently. With an attorney, we would file something called an income withholding order. Same thing as what DCFS would do. Basically, it garnishes the wages of that person. And sometimes this isn't always necessary. Sometimes parents are, more than willing to pay, but it's just easier. It just comes out automatically. They don't have to deal with it. Other times, one parent's not paying, so that's why you have to garnish their wages. Otherwise, you wouldn't be receiving the money. You can also take money from taxes and even retirement if it becomes necessary. Okay. So with imputation of income, that just means that one party is claiming that the other party makes more money than they're saying that they're admitting to. Sometimes this is true, sometimes it's not. When it is true, basically what the other parent has to do is get a vocational examination. And this is, you hire an expert who will examine the other party, kind of see what their marketable skills are, what their education is, what their likelihood of getting a position is in whatever field that they're in, or if they're not in a field, what their likelihood of getting a position is. So basically, I can give you an example with one of the cases we had. There's a party who's, he's a doctor, he went to medical school, he works, but he kind of has his own practice. So what he was reporting he made, our client didn't really feel like that was accurate. So we had a vocational examination done, and it was proven that, in these different markets, he could make this much more money. So the judge imputed income on him. And this income is what was used to determine child support and spousal support. Instead of using what he had reported, they increased it, and that's what the award was based upon for child support and spousal support. So I had someone outside come and talk to me earlier about this already this morning. Unfortunately, I'm very close to my grandparents, so unfortunately for grandparents, they don't have a lot of rights if they want to see their children. They kind of will be kept out of the lives of the child if the parents feel that that's best for the children. So there are very, very limited circumstances where the grandparent can petition for any kind of rights, visitation rights, custody rights, anything like that. Basically when they can do it is if the two parents are divorced and the child's only living with one parent, or even if the parents aren't divorced, if the child's not living with either one, if they're living with some third party, then the grandparent can ask the court to let them have custody of the child or see the child have visitation. And also, of course, if there's criminal records, going back to what we talked about earlier, like, abuse of illegal substances and things like that are going to be an issue for the judge to decide. So the grandparent can petition, but it's hard for them to win. And the court still uses that best interest standard because always when you're deciding where to put a child, you want to decide what's best for the child as to where you're going to put them anyway. Alright, so basically at Stella & Kennedy, we give a free 15-minute consult. So if you want to call in, you can call in. to these phone numbers, and we give a free 15-minute consult. After that, if you want to come in for a meeting, we would have a meeting with you, and then you could decide if you want to retain our firm or whatnot. But we would start with the consultation.